Welcome to our YouTube video series on corporate business law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be looking at the corporate law concept of the reporting issuer. A reporting issuer is a person or company known as an issuer that either 1. has outstanding securities, 2. is issuing securities, or 3. proposes to issue securities and is looking to issue securities under prospectus in furtherance of the securities legislation of the jurisdiction within which the person or company is subject to. An issuer can also become a reporting issuer through a reverse takeover or other corporate transaction involving an existing public reporting issuer or a direct listing on a recognized stock exchange. As a reporting issuer, the issuer is subject to continuous disclosure rules and periodic reporting. With that being said, one needs to delve into the jurisdiction's securities legislation and the interpretation thereof from both the courts and the securities regulator to understand the specific nuances associated with who is and isn't a reporting issuer. In the province of Alberta, we look to the Alberta Securities Act, starting with a definition of a reporting issuer at the very outset of the legislation, which is found at 1 sub CCC. Reporting issuer means an issuer, 1. that has issued voting securities on or after October 1st, 1967, in respect of which a prospectus was filed and a receipt for it obtained under a predecessor to this act, or in respect of which the Securities Exchange Takeover Bid Circular was filed under a predecessor of this act. 2. That has A. filed a prospectus for which the Executive Director has issued a receipt under the act, or B. filed a Securities Exchange Takeover Bid Circular under this act on or before June 1st, 1999. 3. Any of whose securities have been at any time since February 1st, 1982, listed and posted for trading on an exchange recognized under Section 62 by the Commission, regardless of when the listing and posting for trading commenced. 4. That has exchanged its securities with another issuer or with the holders of the securities of that other issuer in connection with an amalgamation, merger, reorganization, arrangement, takeover bid, or similar transaction, if one of the parties to the amalgamation, merger, reorganization, arrangement, takeover bid, or similar transaction was a reporting issuer at the time of the amalgamation, merger, reorganization, arrangement, takeover bid, or similar transaction. That is declared, deemed, or designated to be a reporting issuer pursuant to any other provision of Alberta securities law. To delve further into the process by which an issuer becomes a reporting issuer, the most common practice of becoming a reporting issuer in a Canadian jurisdiction is to file a prospectus with the appropriate jurisdiction's securities regulator and obtaining a receipt for that prospectus. An issuer may file a prospectus in some jurisdictions but not in others, and so become a reporting issuer in only some jurisdictions of Canada. And as previously stated, an issuer can become a reporting issuer in other ways, including A. by having its securities listed on an exchange recognized by the jurisdiction's securities regulator, for example, the TSX Venture Exchange, which has been recognized by both the Alberta Securities Commission and the British Columbia Securities Commission. An issuer whose securities trades on that exchange will be a reporting issuer in both of those provinces, regardless of whether it has filed the prospectus in those jurisdictions. B. Furthermore, under Multilateral Instrument 51-105, issuers quoted in the U.S. over-the-counter markets. An issuer whose securities are not listed on certain specified exchanges may become a reporting issuer if it has been assigned a ticker symbol to trade in the U.S. over-the-counter markets. And C, by amalgamating or combining with another issuer that is already a reporting issuer, oftentimes in the context of a reverse merger. In this context, a reverse merger involves a non-reporting issuer acquiring a reporting issuer by becoming the controlling shareholders of the reporting issuer. And after the acquisition is complete, the newly controlling shareholders reorganize the reporting issuer's assets and operations to absorb the non-reporting issuer therein. Although in some international jurisdictions, an issuer may become or may be required to become a reporting issuer when it has a certain number of security holders. This is not the case in many Canadian jurisdictions. Thank you.